Case number 1. Ernest Ray Willis. In 1986, investigators collected samples from Pecos County, Texas, home where 2 women had died in a pre-dawn fire. They sent those samples to a laboratory. The results came back negative. No accelerant detected, no flammable liquid, nothing to suggest the fire was anything other than accidental. The investigators proceeded with the murder case anyway. Ernest Ray Willis was a roughneck oil field worker in West Texas, the kind of man who moved from job to job and town to town, leaving no deep roots and few advocates. He had no standing in the Pecos County community. He was a guest at the house through a connection to his cousin, a stranger to the neighborhood, a transient in a place where that word carried its own quiet verdict. When fire investigators needed someone to fit the evidence they had decided to see, Willis fit the profile they were looking for. Betsy Ballou was 25 years old. Gail Allison was 24. They were friends of Willis's cousin, adult women staying at the same house on the night of the fire. They did not escape. Willis did. The fire broke out in the early morning hours. Investigators arrived at the scene and conducted a visual examination of the wreckage. They identified what they called pore patterns on the floors, areas of deep charring they attributed to a flammable liquid. They pointed to crazed glass. The spiderweb cracking of window panes they claimed indicated an accelerant-fueled blaze. They noted V patterns climbing the walls, which they described as definitive evidence of intentional burning. 3 indicators, all visual, all drawn from the investigative practices of a decade that had not yet questioned whether those practices had any scientific basis. The chemical tests, which found no accelerant whatsoever, were set aside. A motive was assigned, vague, unsubstantiated, something to do with a drug-fueled rage, and Willis was charged with capital murder. The state of Texas sought the death penalty. The prosecution's fire expert took the stand and testified with confidence that the charring on the floorboards could only have been produced by a flammable liquid. This was stated as fact despite the negative laboratory results already in the case file. The defense presented no fire expert in response. No one testified to what the chemical tests actually showed. The jury convicted Willis of capital murder. He was sentenced to death. Willis spent 17 years on Texas death row. For 23 hours of every day, he was confined to a cell in solitary. Prison psychiatrists administered medication against his will, heavily sedating him in ways that blunted his thinking and his affect for years at a time. He had been convicted of a crime the laboratory evidence had already contradicted before the trial began, and he was being chemically managed while he waited to die for it. In 2004, pro bono attorneys enlisted fire experts trained in the standards established by the National Fire Protection Association, the NFPA 921, guidelines that had, by then, systematically dismantled the visual inspection mythology of the 1980s. Those experts examined the evidence and identified the true source of the fire: an electrical fault in a ceiling fan. The pore patterns that had sent Willis to death row were flashover damage, a natural consequence of a room fully engulfed in fire, a phenomenon that produces floor-level charring indistinguishable to an untrained eye from the residue of a poured accelerant. Willis was officially exonerated and released. He received more than $400,000 in compensation from the state of Texas. He returned to a quiet life. The psychological toll of 17 years in solitary confinement, of forced medication, of facing execution for a fire caused by a ceiling fan, left marks that no compensation figure addresses. His case became a cornerstone of the effort to reform fire investigation standards in Texas. Evidence that the state's arson methodology had been sending people to death row on science that was never science at all. Case number 2. Han Tak Lee, Han-Tak Lee spent 24 years in a maximum security Pennsylvania prison writing letters. His English was imperfect. He was a South Korean immigrant, a clothing store owner from New York, a man for whom the language of the courts and the prisons and the appeals process was a second language navigating a system that conducted itself entirely in the first. The letters went to innocence organizations. Most went unanswered for years. He was writing to tell them that a fire investigator in Monroe County had looked at a burned cabin and seen 62 gallons of deliberately poured heating oil, and that a laboratory would one day confirm there was none. Lee had built a life in New York as the owner of a successful clothing store. He was respected in his community, known as a family man, a person of standing who had no criminal record and no history of violence. He carried with him the particular vulnerability of a man for whom English was a second language, navigating a legal system conducted entirely in the first, a gap that would compound every injustice that followed. His daughter, Ji-Yun Lee, known as Monica, was 20 years old. She was a college student who struggled with severe depression, a young woman whose illness was, by the prosecution's account, the reason her father killed her. Monica and her father had traveled together to a religious retreat in Monroe County. They were staying in a cabin. They were there together. The fire consumed the cabin while they were inside. In 1989, the cabin burned. Monica died in the blaze. Fire marshals produced findings drawn entirely from visual inspection. They identified what they described as alligator charring. Deep, patterned blistering of the wood they attributed to prolonged contact with a liquid accelerant. They noted crazed glass, the fractured window panes they associated with accelerant-fueled heat. They counted what they called multiple points of origin. From these three visual indicators, investigators concluded that 62 gallons of heating oil had been deliberately poured. The prosecution built its theory of motive on the claim that Lee, ashamed of his daughter's mental illness, had brought her to a remote location and burned the cabin down around her. The state's fire investigator testified that the severity of the wood blistering was proof of accelerant use. No chemical confirmation was presented because none existed. Lee was convicted of first-degree murder and sentenced to life without parole. He spent 24 years in a maximum security Pennsylvania facility. The language barrier that had made his trial difficult made his incarceration isolating in ways that went beyond the physical. He grieved his daughter. He was branded her killer. He spent years writing letters in broken English to innocence organizations, trying to reach anyone who would look at the evidence again. In 2014, someone did. Arson expert John Lentini, one of the foremost fire science authorities in the country, examined the evidence and applied the standards that had, by then, rendered the state's methodology professionally indefensible. Lentini demonstrated that the flashover dynamics of the cabin fire fully explained every characteristic the original investigators had attributed to accelerant use. The charring depth, the glass fracturing, the apparent multiple origins. All of it consistent with a natural fire that had reached flashover. Gas chromatography testing, conducted at last, found no heating oil in the evidence. None. A federal judge vacated Lee's conviction. Han-Tak Lee was released. He was 79 years old. He received a significant civil settlement from the state and was reunited with surviving family members. His case catalyzed a comprehensive review of arson convictions across Pennsylvania. A reckoning with how many other people remained in prison because an investigator had once looked at charred wood and believed they knew what they were seeing. Case number 3, Sonia Casey. The body bag was a standard piece of forensic equipment, the kind used routinely at every fire death scene in Texas. When Bill Richardson's remains were transported from the Fort Stockton house where he died, the bag went with him. Later, a state forensic chemist analyzed Richardson's clothing for evidence of an accelerant. He found a chemical signature he identified as proof that a flammable liquid had been used. He was wrong. The signature came from the melting plastic of the body bag itself and from the soles of Richardson's shoes. The instrument of routine death processing had been misread as evidence of murder, and Sonia Casey would spend years in prison because of it. Casey was a homemaker living in Fort Stockton, Texas. She had no criminal record. She had spent years living with and caring for her uncle, an elderly man who needed looking after and who she had looked after without incident, until the fire that killed him became the fire the state said she set. Her years of caregiving, the most intimate evidence of her character, were reframed by the prosecution as the long setup for an inheritance plot. Bill Richardson was 76 years old. He was Casey's uncle, a man she had lived with for years, a man who died in the home they shared. The prosecution alleged that Casey killed him for the modest estate he would leave behind. In 1991, a fire broke out in their Fort Stockton home. Richardson died in the blaze. Investigators examined the scene and identified what they described as a pour pattern on Richardson's clothing, an area of burning they attributed to deliberate application of an accelerant. The state forensic chemist analyzed the clothing and testified that his tests confirmed the presence of a flammable liquid. Casey was charged with murder. The defense could not afford to retain an independent forensic chemist. There was no counter-testimony. No one took the stand to tell the jury what the chemist's equipment had actually detected, or what it might have detected instead. The prosecution presented the visual burn pattern and the chemist's testimony. Casey was convicted of murder and sentenced to 99 years in prison. She served 6 years in a high-security women's facility in Texas. The physical conditions were hard. Her health deteriorated. She mourned her uncle and carried the accusation of having killed him. In the years that followed, independent forensic chemists reviewed the laboratory data that had put her there. What they found was not evidence of an accelerant. What they found was a misreading. The original chemist had interpreted his gas chromatography results incorrectly. The chemical signature he had identified as a flammable liquid was, in fact, the product of melting plastic from the body bag used to transport Richardson, combined with the residue from the rubber soles of his shoes. It was, in other words, evidence of nothing. Casey was released on parole in 1998. The legal process of clearing her name entirely would take another 18 years. Her full exoneration was not finalized until 2016. She received state compensation. The exoneration formally cleared her record. Her case exposed systematic failures in the Texas State Crime Laboratory, failures in training, in methodology, in the basic interpretive standards that should govern how a chemist reads his own instruments. A woman spent years in prison and decades in legal limbo because a body bag melted. Case number 4, Claude Garrett. The jury deliberated for less than a day. 30 years later, the Tennessee Innocence Project would bring in nationally recognized fire experts who examined the same evidence and reached a different conclusion. The pour patterns on the floorboards, the visual finding on which the state built its entire case, were the product of radiant heat, of flashover, of a natural fire burning in an enclosed space, doing exactly what natural fires do. There had been nothing unusual about the fire that killed Lori Lance. The jury that took less than a day to decide Claude Garrett's fate had been told otherwise. Garrett was a working-class man in Old Hickory, Tennessee. He had a steady job. He was engaged. He and Lori Lance shared a rented house, the ordinary domestic arrangement of two people building a life together. Lori Lance was 24 years old. She was Garrett's fiancée. When the fire engulfed their rented house in 1992, she died of smoke inhalation. Garrett escaped. The state fire marshal arrived and conducted a visual inspection of the burned structure. He identified what he described as a distinct pore pattern on the deeply charred floorboards. Charring he attributed to a deliberately applied flammable liquid. He noted V patterns climbing the walls, which he characterized as definitive proof of arson. Prosecutors assembled a motive. A domestic dispute had preceded the fire. There was no evidence of any dispute, no witness to an argument, no documented history of conflict, no physical indication of a confrontation before the fire. Garrett was charged with felony murder. The state's expert testified at trial that the burn patterns were chemically induced. No independent fire expert testified for the defense. The jury deliberated for less than a day and returned a guilty verdict. Claude Garrett was sentenced to life in prison. He spent 30 years in Tennessee state prisons. In the absence of any other recourse, he built a discipline around his own defense. He researched fire dynamics. He studied the NFPA 921 standards as they developed and were refined over the decades he was incarcerated. He filed pro se appeals. He became, through necessity and through 30 years of focused effort, an expert in the science the state had used against him, and in the science that would eventually prove it wrong. The Tennessee Innocence Project took his case. The experts they retained examined the floorboard evidence and found what decades of developing fire science had made clear. Radiant heat and flashover produce floor-level charring that is visually indistinguishable from the residue of a poured accelerant. Every pattern the state's investigator had identified as proof of arson was consistent with a fire that began and spread naturally. A judge ruled that Garrett's conviction had rested on debunked junk science. He was released in May 2022. He had 5 months. He spent them reconnecting with his daughter. In the fall of 2022, Claude Garrett died of natural causes. He had spent 30 years mastering the evidence of his own innocence and lived just long enough to hear a court agree with him. The fire he was accused of setting was accidental. The 30 years were not. Case number 5. William Amor vodka contains approximately 40% alcohol. At that concentration, it will not ignite from a smoldering cigarette. The chemistry is not disputed. An open flame will ignite it. An ember will not. This is not a matter of interpretation or competing expert opinion. It is a property of the substance. The state of Illinois convicted William Amor of murder on the basis of a mechanism that is physically impossible, extracted from him after 15 hours of interrogation, and validated by fire experts who apparently did not test whether the scenario they were endorsing could actually occur. Amor was living in Naperville, Illinois, in a condominium he shared with his wife and his mother-in-law. He had a history of substance abuse and a volatile marriage. Circumstances the prosecution would later use to construct a portrait of a man with reasons to be dangerous. He struggled to maintain steady employment. He was, by most measures, in a difficult period of his life when the fire happened. Marianne Misselli was 40 years old. She was Amor's mother-in-law, a woman who shared the condominium with him and his wife. She died in the fire that consumed the unit in 1995. Police interrogated Amor for 15 hours. At the end of those 15 hours, he signed a confession. In it, he stated that he had taken a newspaper, soaked it in vodka, placed a smoldering cigarette on top of it, and used the combination to start the fire. He recanted the confession at trial. He told the court that the interrogation had produced a statement he had not freely given. The prosecution brought in arson experts to validate the mechanism described in the confession: the cigarette, the vodka, the newspaper, and the experts obliged. Amor was convicted of murder and aggravated arson and sentenced to 45 years. He served 22 years in Illinois maximum security prisons. The psychological burden of a false confession does not resolve the way a simple injustice might. A man who signed his name to a statement describing something he did not do carries the weight of that signature differently than a man who was simply in the wrong place. Amor maintained his innocence throughout. The confession had been coerced, he said. The science was wrong, he said. 22 years passed. In 2017, the Illinois Innocence Project presented laboratory evidence proving that a lit cigarette cannot ignite vodka. The alcohol content, 40%, requires a direct flame to combust, not a smoldering ember. The mechanism described in the confession was impossible. Amor was retried. In 2018, he was fully acquitted. After his release, he filed a federal civil rights lawsuit against the Naperville Police Department for the coerced confession and the fabricated science that had supported it. The case against him had never rested on what happened in that condominium. It had rested on 15 hours in an interrogation room and a fire expert who validated a chemical impossibility without checking whether it was possible. Case number 6. John Galvin. In his prison cell, John Galvin watched an episode of MythBusters. The show's hosts were testing whether a lit cigarette could ignite a pool of gasoline. The test was definitive. It could not. The cigarette went out. The gasoline did not catch. Galvin had signed a confession in 1986 stating that he had thrown a lit cigarette onto pooled gasoline to start a fire. He had been 18 years old when he signed it. He had testified that he was beaten into signing it. He had known for years that what the confession described was impossible. Now he was watching cable television confirm it in a garage somewhere, and he had been in prison for the better part of 2 decades already. Galvin was 18 years old when Chicago police took him in for questioning about a fire that had killed 2 men in a residential row house. He had no serious criminal history. He grew up in a neighborhood shaped by gang violence, which made him, in the logic of the investigation, a plausible suspect. He was beaten, he would later testify, until he signed the statement they put in front of him. The statement said he had thrown a lit cigarette onto a pool of gasoline. Guadalupe Martinez was 28 years old. His brother Julio Martinez was 19. They were adults living in the Chicago row house that burned in 1986. Both died in the fire. Their deaths were real, and whoever was responsible for them had not been identified by the investigation that followed, only by a confession extracted from a teenager who said he was beaten. Fire investigators examined the scene and produced findings in the language of 1980s. Arson science. They identified crazed glass, the fractured window panes associated in that era's methodology, with accelerant-fueled fires. They noted what they called clean brick, areas of the structure they claimed indicated abnormally intense heat from a liquid accelerant. From these 2 visual indicators and the signed confession, they built a case. Galvin testified at trial that he had been physically coerced into confessing. The judge permitted the fire science testimony to stand regardless. Galvin was convicted and sentenced to life without parole. He spent 35 years in Illinois state prisons. He watched the MythBusters episode. He contacted the Innocence Project. It took another decade. In 2022, fire expert Dr. Russell Ogle testified that the state's reliance on crazed glass and clean brick as indicators of accelerant use had been completely repudiated by modern fire science. Neither phenomenon current research had established required accelerant to produce. He also confirmed what the television program had already demonstrated. It is physically impossible to ignite pooled gasoline with a cigarette. The confession described something that could not have happened. Galvin and his 2 co-defendants were fully exonerated. They were released. They received a civil settlement that reflected, at least in financial terms, what 35 years costs. Galvin had been 18 when the state took him. He was in his early 50s when it gave him back. The combination of junk science and documented police torture that produced his conviction was not unique to his case. It was, as his exoneration made clear, a method. The settlement acknowledged the outcome. The 35 years are not recoverable. Case number 7, Weldon Wayne Carr. When prosecutors began preparing for the retrial of Weldon Wayne Carr, they went looking for a fire expert. They needed someone with current credentials and standing in the field who would testify that the 1993 visual inspection of the Carr estate had correctly identified the fire as arson. They did not find one. Not one credentialed fire scientist was willing to stand behind the pore patterns, the puddle configurations, the alligatoring that had convicted Carr of killing his wife. The science that had sent him to prison had become professionally indefensible. By the time the state acknowledged it could not retry the case, Weldon Wayne Carr had been out of prison for 7 years. Released after the Georgia Supreme Court overturned his conviction, but still legally accused, his name still formally attached to his wife's death. Carr was 58 years old and a retired business executive when Patricia died in the fire at their Sandy Springs, Georgia, estate in 1993. He was a man of standing, wealthy, socially embedded, the kind of person for whom the machinery of accusation is not supposed to work the way it worked for him. Junk arson science does not discriminate. It burned through the professional reputations and remaining years of transient oil field workers, and it burned through those of retired executives with equal indifference to status. Patricia Carr was Weldon's wife. They lived together in a sprawling estate in Sandy Springs. She died in the fire. Her husband escaped. Fire investigators arrived and conducted their examination. They identified pore patterns on the floorboards. Areas of deep charring they attributed to a deliberately applied accelerant. They noted what they called puddle configurations, visual formations consistent, by their methodology, with pooled flammable liquid. They described the fire as burning unnaturally hot and fast. They cited the alligatoring of the wood, the deep, patterned blistering that 1980s arson science had classified as an accelerant indicator, as definitive evidence of intentional burning. The assigned motive was financial. Carr, investigators concluded, had wanted to avoid the cost of a divorce. No divorce proceedings were documented. No financial records were produced to substantiate the claim. It was the motive a fire investigation produced when it needed one. Carr was charged with malice murder and first-degree arson. The state's expert testified that the fire burned unnaturally, that the alligatoring of the wood proved what the investigator said it proved. The jury convicted. Carr was sentenced to life imprisonment. He served 3 years before the Georgia Supreme Court intervened, not on scientific grounds, but on the grounds of prosecutorial misconduct. The state had not simply used bad science. It had behaved improperly in building the case, and the court recognized it. Carr was released in 1997. During preparation for the retrial, independent forensic testing was conducted. The pore patterns were proven to have no evidentiary value. The fire was determined to have been electrical in origin. And when the state went to find an expert willing to defend the original arson theory, under cross-examination by lawyers who now knew the science, it found no one. The charges were formally dropped in 2004. Carr was fully cleared. He had been out of prison for 7 years before the state stopped formally accusing him of his wife's death. His reputation and his finances had not recovered from what the accusation cost them. The lead prosecutor in the case faced scrutiny for the misconduct finding and for the willingness to press a murder case on visual evidence that could not survive scientific review. Case number 8, Frederick Spencer. A trauma nurse was present when Frederick Spencer arrived for treatment after the fire that destroyed his home in Shepherd, Michigan in 2006. She saw something before she saw his burns. She saw a man who had run back into a burning house. She was in the courtroom later when the prosecution argued that Spencer's burns proved he had poured an accelerant and ignited it himself, accidentally burning his face in the process. She told the court what she had seen. The prosecution told the jury that the burn patterns on the structure were more probative than the testimony of the medical professional who had witnessed the man running into the flames. The jury agreed. Spencer was sentenced to life in prison. Spencer was a blue-collar worker in Shepherd, Michigan. He had a stable relationship and a quiet life in a small, rural town. Nothing in his history indicated escalating violence, documented conflict, or the kind of pattern that might have served as context for the theory of deliberate killing. Kathy Sitek was Spencer's girlfriend. She lived with him in the home. She died in the fire. He did not. In 2006, a fire destroyed Spencer's house. He escaped, but he emerged with severe burns to his face. Sitek did not escape. Fire investigators examined the scene and concluded that the fire had spread too rapidly to be natural. The speed of the spread, they argued, indicated accelerant use. The theory they constructed was specific. Spencer had poured a flammable liquid through the structure. The liquid had caught, and Spencer had been burned on his face as it ignited. His injuries were not evidence of a rescue attempt. They were evidence of the crime. The trauma nurse who treated Spencer told the court she had witnessed him run back into the burning house. The prosecution countered with burn pattern analysis. Spencer was convicted and sentenced to life. He served 7 years. His burn injuries were not adequately treated during his incarceration, and he endured years of physical complications from the original wounds. The psychological burden was distinct from the physical. The particular weight of a conviction that had taken the most visible evidence of his innocence and turned it against him. Both were present throughout those 7 years. The Michigan Innocence Clinic took his case. Modern fire experts examined the evidence and reached the conclusion that the fire's rate of spread was entirely consistent with standard flashover, a natural fire behavior that produces rapid, dramatic spread in enclosed spaces without any accelerant required. A federal judge granted habeas relief on 2 grounds. The fire science was fundamentally flawed, and Spencer's trial counsel had been constitutionally ineffective in failing to challenge it. He was released in 2013. Spencer returned to his community and focused on medical recovery from his burns. Injuries he had sustained going back for the woman he was convicted of killing. He has continued to speak out against the visual burn pattern, testing methodology that was used to construct the case against him. He still carries the physical evidence. The prosecution called it guilt. The Michigan Innocence Clinic called it something else.